Assalamualaikum warahmatullahi wabarakatuh. I am Ahmad Faiz Aiman bin Mohamed here, a final year student from UiTM Segamat Johor, and I will present an issues and ethics in finance, which is insider trading of Stanley. But before I dive into the issues regarding insider trading of Stanley, let me give a brief overview as to what insider trading really means. So, insider trading refers to a dealing in shares by a person who have access to a corporate non-public information affecting the value of shares. Example, a director of a company who, after knowing some favorable news such as a research breakthrough or an award of a huge project to the company, buys himself a large amount of shares in that company in order to make profit. And also the case is similar when a finance director who sells all his shares shortly before the announcement of a financial loss. Insider trading happens when someone makes an investment trade based on material information that's not publicly available. In market terms, material information is any detail that could affect a company's stock price. This information gives the individual an edge that few others don't have. For example, the announcement of a tender offer, a pending merger, a positive earnings report, and the pending release of a new product. The reason insider trading is prohibited because the upholding of the principle of fairness. It is unfair to allow an executive to use corporate information for personal gain. The practice would give rise to unfairness to the investors who are not insiders or have access to the information. Insider trading is illegal because it gives the insider an unfair advantage in the market, puts the interests of the insider above to whom they owe a fiduciary duty, and allows an insider to artificially influence the value of a company's stock. Someone who engaged in insider trading can face serious legal action, and insider trading and their accomplices could face considerable fines and even federal prison sentences. The kind of information under the context of insider trading is wide and covers various instances. What constitutes as information is that information can be matters of supposition and other matters that are insufficiently definite to warrant being made known to the public, matters relating to intentions or likely intentions of a person, and matters relating to negotiation or proposals with respect to commercial dealings or dealings in securities. The information can also relate to a financial performance of a corporation that a person proposes to enter into or has previously entered into one or more transactions or agreement in relation to securities, or has prepared or proposes to issue a statement relating to such securities and matters relating to future. Okay, now we can go into the details of insider trading of Stanley. Back in 2007, a chief executive officer of APL Industries Berhad, Datuk Sri Stanley was charged with insider trading offences involving APL Industries Berhad shares. Stanley, who was back then a CEO of Supermax Corporation Berhad, had allegedly communicated inside information to remiser Tiong Kiong Chun on the price or value of APL Industry shares, which was generally not available in 2007. On that hearing, the judge granted RM 250,000 bail and surrendered Thai's passport. Then in 2009, after the offences committed by Thai, the APL Industries was delisted from Bursa Malaysia. as the offences were deemed more serious than conventional crimes. On November 2017, the Securities Commission Malaysia said Session Court judge sentenced to a 5-year jail term and a Rm 5 million fine, making it the first time it has been imposed on a person for insider trading. The remiser, Tiong Kyong Chun, also convicted on 2 accounts disposing the information, and at that time he was a licensed intraday trader with a stockbroking company, making Kyong's sentence to 5-year jail term and Rm 10 million fine. After an appeal filed by Stanley and Tiong Kyong Chun against the conviction and sentence imposed by Session Court in 2017, the Judicial Commissioner of High Court makes an overturn and reverse the Sessions Court's decision on 2017, as the Judicial Commissioner found the conviction not safe after hearing the submissions. The Judicial Commissioner made the decision after hearing submissions from both sides for 4 hours, focusing on the perpetrated on the phone call between Thai and Kyong, as they cannot rely on the telephone records without any evidence of the phone being tapped or other information to convict Kyong of insider trading unless they brought witness to testify the conversation between Thai and Kyong, in which the prosecution didn't. For all that reason, the Judicial Commissioner submitted that the conviction of Tiong was not safe and the court should set aside the conviction and sentence. And until today, the case is still ongoing, with the charge under Capital Markets and Services Act 2017 of insider trading, in which carries a maximum jail term of 10 years and a fine of not less than Rm 1 million. Upon hearing the case of Stanley Thai, what is the effect of this case? Insider trading can erode investor and market confidence, evidently from the case of Stanley Thai, where the company APLI was delisted from Bursa Malaysia. Due to this sort of cases, many countries enacted legislation prohibiting insider trading. However, cases of violation of confidential information by insiders still occur, and the loss is often massive. Insider trading promotes informational disadvantage for those who have no access to the confidential information. The public confidence in the security market will be gone, as there is no more a level playing field in the capital market. According to Newkirk, he affirms that investors' confidence is necessary for maintaining healthy markets, and investors' confidence is determined by his or her belief in fairness in terms of information disclosure and protection in case of insider trading occurred. Investors' perception of justice is important for maintaining confidence in capital market. Investors who feel that they have been unfairly victimized in share dealing might move their capital market. This rationale explains the effort by many countries to prohibit insider trading. The need to protect investors' confidence and the integrity of security market has become the main reason by the Malaysian authorities to enact laws against insider trading. Strengthening insider trading law is very crucial if securities market wishes to attract foreign investment in the future. The chairman of Securities Commission announced that improving market transparency and corporate governance would be an important recovery objective for capital market. And to achieve these objectives, number of statutes such as Company Act 1965, Securities Industry Act 1983, Futures Industry Act 1993, and Capital Market and Services Act of 2007. Despite many attempts by the Security Commission, fighting insider trading is not always an easy task. Using criminal law as a tool to bring the offenders to justice may have its drawbacks, including the high burden of proof and the deliberate procedural matters to comply with. After knowing the case of insider trading of Stanley, let's dig deeper onto the criticism and recommendation regarding the case. Trading through insider is deemed as white-collar criminal offense. In order to curb this unjustness, prevention among market participants is vital and should be held responsible to each market participant. If you came across into possession of inside information, what the most moral thing we should do is to not trade these securities based on the information given or found. A trader must not communicate such information to anyone, including their loved ones, relatives, friends, and business associates, as this spreading of information might increase the engagement and behavior of trading using inside information, by which is a serious criminal offense. A trader can only use the inside information when the information has been made public through a proper channel and sufficient time have elapsed to allow investors to digest and understand the implication of the information. Individual advisors such as lawyers, accountants, and consultants who come into possession of inside information in the course of carrying out their work should not share the inside information with anyone, including their colleagues who are not involved in the work at hand. If the individuals are found caught red-handed, not only will their professional career and credibility would be affected, they could also face a serious criminal charge under the federal law. On the company perspective, company must safeguard information by making sure it steps up, enhance, and enforce its governance system and controls to safeguard material non-public information concerning the company. A company must manage their flows of inside information by putting in place a barrier to block and prevent information from any leakages. Through continuous and rigorous effort, a company must create awareness amongst its employees and the importance of managing flows inside information. Difficulties with the enforcement may defeat insider trading laws. Being a white-collar criminals, insider trading offenders are better able to calculate the risk of their offenses. Hence, the problems with the enforcement will encourage these criminals to commit the crime, by which we can put the case of Stanley as example. The prolonging case of Stanley ties since 2007 until the court section verdict in 2017 with a Rm 5 million fine and 5-year jail term was set aside in the court in 2020 due to unsafe conviction. It goes to show that the flaws in the law enforcement despite many prohibited of law in insider trading. To prosecute a white-collar criminal is not an easy task, and this gave many loopholes to future insider trading criminals to commit the same crime as Stanley Thai. In conclusion, insider trading is considered a serious criminal offense because it involves misappropriation and the taking advantage of inside information which should rightly belong to the company. Insider unjustly enriches themselves to the detriment of others based on the inside information, the unfairness to the other market participants who are not in the position to gain access to similar inside information, and insider trading injures the overall market confidence of the stock market. Insider trading can be detrimental to national economic performance of a country in terms of the loss or reduced number of potential investors. It is crucial that the case of insider trading is given much attention if a government of a country wants to promote and instill investors' confidence to the security market. In order to provide a more structured and comprehensive way of addressing the problem of insider trading, we must first understand the reasons which led people to commit insider trading and identifying the problematic aspects under the existing law combating insider trading. The laws imposed by the government are generally satisfactory. However, the rate of prosecution is very low, and the problems are largely contributed by difficulty to implement and enforce criminal law in prosecuting the alleged criminal. In order to revive investors' confidence and confer benefit to the victims, Security Commission of Malaysia has made use of the civil suit provisions against the alleged insiders. With an improved law enacted, it may be thought that the civil suit provides a good option for the regulators to combat insider trading. We have arrived at the end of this video. I want to thank you for watching this video presentation about insider trading of Stanley Thai until the very end. I really appreciate it. I hope you guys can have an idea and insight to what insider trading really means and how it can affect the market as a whole. By my sharing of the case of insider trading of Stanley Thai, I hope we can use it as an example as to not follow his footsteps by trading legally and justly, as insider trading is considered as law offense and the punishment is very severe. So trade wisely, and thank you for watching. Stay safe and Assalamualaikum warahmatullahi wabarakatuh.